Stop what you're doing for just a moment, because what happened behind closed doors in Congress didn't just add another chapter to Washington drama, it quietly shifted the entire impeachment landscape. This wasn't a headline designed to trend. This was one of those rare moments when the machinery of government actually moved in a way that matters. Yesterday afternoon, at exactly 3:15 p.m., CIA Director John Ratcliffe walked out of a secure congressional facility after 6 hours of sworn testimony before the House Intelligence Committee. And what followed was not spin, not leaks from anonymous staffers, and not speculation from cable news panels. What followed was an immediate institutional response that tells us something serious occurred. Before you assume this was just another partisan showdown, it's important to understand what triggered this testimony and why it carries so much weight. This wasn't a whistleblower complaint filtered through intermediaries. This wasn't background chatter from unnamed sources. This was the sitting director of the Central Intelligence Agency testifying under oath in a classified setting, providing information that directly conflicted with prior White House statements about how classified intelligence was handled and how foreign communications were conducted. That distinction matters. When the head of the CIA spends 6 hours answering questions that lead lawmakers to begin drafting an impeachment inquiry resolution, it's not political theater. It's an alarm signal. Most media coverage immediately gravitates toward personalities who's angry, who's defensive, who's pointing fingers. But that misses the core issue. The real story is what this testimony revealed about alleged intelligence protocol violations. When intelligence chiefs contradict executive branch claims, this stops being a political disagreement and becomes something far more serious. It becomes an institutional crisis. Here's what many people don't fully grasp. CIA directors testify to Congress regularly, but they almost never do so in a way that directly undermines a sitting president's factual assertions. These officials are appointed by the president. They typically defend the administration, smooth over discrepancies, or keep disagreements behind closed doors. When that pattern breaks, it tells us the issue has crossed out of politics and into national security risk. To understand why this testimony matters so much, you need to understand the environment where it happened. This wasn't a public hearing with cameras, prepared statements, or viral sound bites. It took place inside a SCIF, a sensitive compartmented information facility. No phones, no aides, no audience. Just the CIA director, members of Congress, and classified truth delivered under oath. According to official committee statements and congressional source reporting, the questioning focused on 3 specific areas that go to the heart of intelligence integrity. The first was unauthorized disclosures. Ratcliffe was questioned about instances where classified intelligence was allegedly shared with foreign officials during private meetings without intelligence officers present and without formal declassification. That detail is critical. In intelligence operations, documentation is everything. When a president meets a foreign leader, trained note-takers are supposed to be present. That's not bureaucracy for its own sake. It's how the intelligence community knows exactly what was said, what was shared, and what commitments may have been implied. When information is shared off the record, the system loses visibility. According to the testimony, this didn't happen once. It happened repeatedly. That leads directly into the second area of concern, and this is where the gravity really sets in. The second focus of the testimony involved failures in declassification protocol, and this is where misunderstandings often creep in. There's a common myth that a president can simply declare information declassified at will. In reality, intelligence handling follows strict procedures designed to protect lives and capabilities. Ratcliffe reportedly testified that those procedures were bypassed. To understand why that's dangerous, you need to understand how classification actually works. When a document is labeled top secret, it isn't just stamped and filed away. It carries a control number, appears in a tracking log, and is tied to an originating agency. Declassifying that document typically requires review by the agency that created it because the information may come from a human source, someone whose life could be in danger if exposed, or from a technical system that cost billions to develop. Before information is shared, analysts scrub it to protect sources and methods. That process isn't optional. It's the safeguard. According to the testimony, that safeguard was ignored. Materials were allegedly shared in raw form. That means the protective layers designed to keep intelligence assets alive were stripped away. This isn't a paperwork error. This is a security failure with potentially real-world consequences. The third area addressed was internal concern within the intelligence community itself. Ratcliffe reportedly confirmed that career analysts raised alarms that intelligence was being filtered or shared outside normal channels. In intelligence terms, this is known as politicization. It happens when information that supports a preferred narrative is highlighted, while contradictory intelligence is withheld. That doesn't just distort policy debates, it corrupts national decision-making. This is why the reaction to the testimony was immediate. CIA directors don't typically offer sworn statements that contradict White House positions. They usually defend policy or remain neutral. When one acknowledges under oath that intelligence handling procedures were compromised, it signals institutional distress. This isn't interpretation. It's reflected in the committee chairman's public statement and the bipartisan reactions of members exiting the hearing. Some headlines frame this as the CIA director flipping. That misses the point. What actually happened is that Congress received direct testimony from the official responsible for intelligence protocols, stating that those protocols were not followed. That's not opinion. That's evidence. So what does that mean constitutionally? Article 2, Section 4 of the Constitution allows impeachment for high crimes and misdemeanors. That phrase doesn't only mean criminal acts. The founders intended it to cover serious abuses of power that violate public trust. When a president takes the oath of office, they swear to protect the Constitution, including the national security systems that defend the country. If a president knowingly bypasses intelligence safeguards and exposes sensitive information to foreign actors, that isn't a policy disagreement. It's a breach of the oath. The Federalist Papers make this concern explicit. Hamilton and Madison repeatedly warned about foreign influence and executives who might place personal or political interests above national security. That fear is why impeachment exists. It's the emergency brake. History supports this framework. Andrew Johnson was impeached for violating statutory limits on executive authority. Richard Nixon faced impeachment for intelligence abuses tied to Watergate. Bill Clinton was impeached for perjury, a violation of legal duty. Different actions, same principle. Breach of constitutional responsibility. The argument here is straightforward. If a president cannot be trusted with the nation's secrets, they cannot fulfill the office. Bypassing security protocols isn't a minor error. It demonstrates disregard for the systems that protect the republic. That's the definition of a trust violation. Now that the testimony is on record, the constitutional process begins not in headlines, but in procedure. So what actually happens after testimony like this reaches Congress? The answer matters because impeachment is not a single vote or a sudden event. It's a structured process designed to move deliberately. We are now in the first stage, committee investigation. At this stage, the House Intelligence Committee conducts depositions, subpoenas documents, and compiles evidence. This phase usually lasts between 45 and 90 days. Functionally, the committee operates like a grand jury. It doesn't determine guilt. It determines whether enough evidence exists to move forward. The subpoena power here is critical. In ordinary oversight, the executive branch can often invoke privilege. In impeachment inquiries, courts have historically ruled that congressional investigative authority is at its strongest. Stonewalling becomes much harder. Once that phase concludes, the process moves to the Judiciary Committee. They receive the intelligence findings, conduct further hearings, and determine whether the evidence supports drafting articles of impeachment. These articles are not symbolic. They are formal charges, similar to an indictment. Each article specifies an alleged constitutional violation, abuse of power, obstruction of Congress, violation of the oath of office. If articles are drafted, the process moves to the House floor. Members debate, and a simple majority vote determines impeachment. If that vote passes, the president is impeached. Removal, however, is not decided there. That happens in the Senate. In the Senate trial, the Chief Justice presides. Evidence is presented. Senators act as jurors. Conviction and removal require a 2/3 vote. This structure is intentional. The Constitution demands evidence, debate, and consensus. What makes this inquiry potentially different from past impeachments is the nature of the evidence. In Watergate, intelligence concerns surfaced through reporting and later testimony, but the CIA director did not directly contradict Nixon in real time. In Clinton's case, intelligence was irrelevant. In the former president's prior impeachment, intelligence officials testified, but the CIA director did not, and the focus was foreign policy pressure, not intelligence protocol violations. This is the first instance where a sitting CIA director has testified about ongoing intelligence handling failures while an inquiry is forming. That changes the evidentiary landscape. The person responsible for enforcing intelligence safeguards told Congress they weren't followed. That gives lawmakers direct institutional evidence instead of retrospective reconstruction. There's another layer here. Congress must navigate classified information protections in real time. Typically, classified material is handled through procedures designed for courts. The fact that the intelligence community is cooperating suggests they believe silence poses a greater risk than disclosure. Congress now has the ability to assess evidence immediately, which accelerates the process. But impeachment isn't just about procedure. It's about numbers. And this is where political reality enters. Impeachment, at its core, is a numbers game. In the House, 218 votes are required. With the current narrow Republican majority, Democrats hold roughly 212 votes. That means only 6 Republicans would need to join them for impeachment to pass. That threshold is low enough to make this inquiry viable if the evidence is compelling. The Senate is a different story. Conviction requires 67 votes. With 51 Democrats and independents, that means 16 Republicans would need to vote to remove a president of their own party. History tells us how rare that is. No president has ever been convicted and removed by the Senate. Nixon resigned before a vote. Johnson and Clinton survived. Some argue that intelligence violations are different. National security, they say, is the one line that transcends party loyalty. Others believe polarization is now so entrenched that no evidence could move 16 senators. Both views deserve consideration. The variable is severity. If evidence shows that American lives were put at risk, political calculations change. That's not speculation, that's historical pattern. So where does this leave us? The record is clear. The CIA director testified under oath. His testimony contradicted prior White House statements. House committees now have evidence and have initiated an inquiry. Over the next 30 to 45 days, documents will be subpoenaed. Witnesses will testify. Evidence will be compiled. The Judiciary Committee will decide whether to draft articles of impeachment. This is not a prediction. It's the constitutional accountability process. When credible allegations emerge, Congress investigates. No one is above scrutiny, but everyone is entitled to due process, even in impeachment. The system is slow by design. Evidence first. Debate next. Votes last. And now, the country watches. What happens next will determine whether this moment becomes a footnote or a turning point. Congressional investigators will examine whether intelligence sources were exposed, whether protocols were knowingly bypassed, and whether internal warnings were ignored. These are not abstract questions. They cut to the heart of national security governance. If the inquiry reveals systemic disregard for safeguards, the constitutional implications are serious. Impeachment exists not to punish, but to protect the republic from abuse of entrusted power. That principle has guided every impeachment in American history, regardless of outcome. Public perception will matter. If the public understands the stakes, not partisan advantage, but national security, integrity, pressure on lawmakers will increase. If the issue becomes framed as political retaliation, momentum could stall. This is why the role of evidence is decisive. Not rhetoric, not headlines, documentation, testimony, records. We are watching a rare institutional collision. Intelligence accountability meeting constitutional authority in real time. The outcome is uncertain, but the process is underway. The CIA director testified. Congress is investigating. The constitutional mechanism is moving exactly as designed. Whether this ends in impeachment, acquittal, or something else entirely will be determined not by outrage, but by evidence and votes. This is what accountability looks like in a constitutional republic. Slow, methodical, uncomfortable. If you want to follow this process as it unfolds, not the noise, but the substance, stay with me and tell me this. Does sworn testimony about intelligence protocol violations meet the constitutional standard for impeachment? I read every comment.